Hey everybody, how's it going? Hope you're having a lovely day. I'm not. I'm probably not going to have a lovely day tomorrow, for the next few weeks, and maybe the next few months. I was not planning on doing a video anytime soon because I'm just not in the mood to. However, I've gotten 1,281 emails asking me to cover this Disney case where they have said that they are not accountable or responsible in a court of law for a falsely advertised restaurant that would cater to the allergy of a patron who then died as a result of eating a food with an allergy that their restaurant said would not be there. This is a case where somebody has been massively screwed over, and it goes over the concept of forced arbitration, which is something I've been covering in these videos for the last year. This video is going to be structured in 4 elements. The first one is going to be going over what forced arbitration is. The second is going to be going over some examples of how forced arbitration is pushed on people by way of a retroactively amended purchase experience, whose acronym is quite accurate. The third is going to be going over the facts of the case, and the fourth is going to be going over my opinion. Because this video is going to be everywhere, I'm going to try and provide as many detailed timestamps as I can so that you could click forward to whatever part of the video that you want to. If you're new here and you want to learn what forced arbitration is and what the retroactively amended purchase experience means, you can do that. And if you've already heard my whole spiel on that in all these old videos, please do check the timestamps that you'll see down below. So first things first, what is forced arbitration? Forced arbitration is the idea that a company can contractually allow you to sign away your rights as an American to take a company or an individual to a court to have your day in court if they have screwed you or they've broken the law, which is one of the only ways that we have left as Americans to protect our consumer rights. The FCC fines people 0.2% of their net profit when they break the law and sell your data to bounty hunters, bail bondsmen, advertisers, and everybody else against their own privacy policy. And the FTC will fine companies that break warranty laws $0, even when they have the ability to fine them over $30,000 for each instance of breaking the law. The FTC, the FCC, and consumer protection agencies in the United States are a joke. So consumers usually have to do the legwork themselves because the people that they're giving 37 to 40% of their paycheck to don't do it for them. I don't know what they do all day. Maybe they play air hockey. Maybe they're playing beer pong. I don't know what it is, but it's not working for us. So a couple of examples of this that I'd like to provide here. For those of you who think that taking companies to court is useless and only results in a class action lawsuit where you get a 50-cent check that you could post on your refrigerator with a magnet because it is not even worth the time to open your bank app and deposit it. I go over in many of my videos here. Many of you who are new to the channel may not know, in a prior life, I used to be a repairman, and I went over about 1,000 videos of how to repair Apple products at component level. I was quite an expert in doing this, and I have a video over here where I go over all their flaws over several years. They have a lot of design defects, and Apple is a company that doesn't take accountability and responsibility most of the time when they've done something wrong. They need to be pushed to do so in a court of law. So in a court of law, over here, they were forced to replace keyboards that were defective for free for customers. Here, there were graphics chips that would die on these A1286 MacBooks with an A220-2915 or A220-2914 board, not just when you're video editing. I mean, you could just be viewing an animated GIF at 2 frames a second, and it would still not work, and the GPU would die on this piece of shit. Here you have phones that the touchscreen would stop working on because a chip would start to come off of the board, and you would have to replace the chip, run a jumper wire under it, all this kind of crap. Apple knew about it. Apple didn't care. They sold it to you anyway. And as a result of this, you were entitled to money or a cheaper replaced product. Forced arbitration means that you're not allowed to take companies to court when they produce defective merchandise and screw you over. And this is a really large issue because it's the only route that we have left to exercise our rights as Americans when a company has screwed us out of money or stolen our data and sold it to bail bondsmen, advertisers, and bounty hunters. So let's go over a couple of examples of the second reason that this is an issue, is that most companies are not honest when trying to get you to agree to forced arbitration. They do it in many sneaky ways, or they do it by force. The retroactively amended purchase experience means that a company is trying to change the terms of the sale after they have sold you a product. So you agree to one terms of service, and then they change it to a new terms of service later, and the way that they're able to enforce this usually is by having a cloud-connected device. If you have a device that connects to the internet, that means that it's not like you bought it and owned it. It is cloud connected. If it has to connect to somebody else's computer in order to function, that means that they can turn off the function at any point in time. And if they have the ability to turn off the function at any point in time, you get shit like this. This is an issue that people had with TVs that had Roku, and it would say, we've made an important update. We've updated our dispute resolution terms. Select agree to these updated terms and continue enjoying our products and services. Now, why is this a problem? The first is you bought this television without it having forced arbitration. So you bought it with the idea that if this television died within the warranty period and the company said, screw you, you would have the ability to have a judge or a jury force the company legally to honor your warranty or be in serious shit. They are trying to take that away from you, and you don't have the ability to do anything about this because you can't use your television otherwise. Notice that there's no disagree button here. I'm not allowed to disagree to you changing the terms of the sale, and if I want to change the source on my television with the remote to HDMI, many people were reporting that they couldn't do that. I couldn't use my TV, is what they were saying, until I hit agree. And because this television connects to the internet, the company could just look at you and say, suck it. Like, there's no accountability or responsibility there. Next, we have forced arbitration with socks. I'm not using this example because I really care a lot about socks. It's the principle of the matter, and it's the way they opt you in. Over here, it says that by accessing this website, by accessing or using the website, you are agreeing to the terms of use below. It says SmartWool may amend these terms of use at any time. And the most important one is where it says that if you want to opt out of this, you have the right to opt out by written notice via priority mail or hand delivery within 30 days of the amendment. So they email you an email that is most likely going to go to spam for a lot of people that have emailed me about this. By emailing you something that you never signed, you are now opting in to a forced arbitration agreement. They can opt you in by emailing you. But if to opt out, I have to send you priority mail or hand deliver you a notice. Again, this goes back to the South Park Cable Company CEO, where they're doing this because they realize that there is no consumer protection in America. They opt you in without asking for consent. And they make it as difficult as possible to revoke your consent. Retroactively amended purchase agreement. They may amend these terms of use at any given time. Rape. An accurate portrayal of the mindset of the individuals at these companies that come up with these policies. Blizzard did the same thing, where if you want to play your games, you'll notice here that you have two buttons on the screen. You have agree and you have cancel. You don't have disagree and allow me to play my game. You have agree and then you have cancel. Agree, cancel. You don't have the ability to play your game unless you agree to terms that you did not agree to at the point of sale when you gave them money. One of my favorites is with LG. LG produced refrigerators that failed. In my opinion, you should never buy home appliances that are made by a smartphone manufacturer. And with the case of the last video I did on Xiaomi and cars, for fuck's sake, never buy a car that is designed by a smartphone manufacturer. Just trust me on this one, don't do it. Back to this, LG made refrigerators that failed because of a design defect. These refrigerators failed within the warranty period, and when they failed within the warranty period, LG refused to honor that warranty for their customers. These customers wanted to take them to court because it happened to enough people, and LG said that you're not allowed to take us to court because of a forced arbitration agreement. Now, how are these customers opted into this forced arbitration agreement? Because of a notice in the box. You may notice that when you go to a store, small things are in a box. If you're buying a portable handheld vacuum cleaner, a computer that's this small, you may see stuff like this inside of a box. But when it comes to a refrigerator or really large appliances, you don't see the box in the store, so you never have the opportunity to see that. When your refrigerator is shipped to your home, the box and all the padding inside the box results in it not being able to fit through most people's door frames. And because it doesn't fit through the door frame, the delivery people are often instructed to take the refrigerator out of the box carefully and dispose of the box without that box ever entering the recipient's home. That means that the recipient of this product never gets to see the forced arbitration clause on the box. Therefore, they were never informed of the fact that their rights had been taken away as an American. And further, you should not, even if the consumer did see the box, you're signing claiming that you received it. When you sign for something that you're receiving from Lowe's or Home Depot, you're not agreeing to these ridiculous terms of service from the manufacturer. You're simply signing a bill that says, I received the product that you shipped me. You're not signing away your rights as an American. This is why forced arbitration is complete and utter bullshit. Even if you did not have all these retroactively amended purchase experiences, the mere fact that a company can, by contract, say, you can sign away your rights as an American is insane. Simply because you write a contract saying that you have the right to my firstborn child does not mean that that is legally binding. And the only reason this is legally binding is because we don't have laws in the United States that protect us as citizens. Our politicians care more about dividing us over culture war issues, riling up their base, and getting people to get really, really excited about these things so that they stay engaged and stay angry and vote for them, allowing them to continue to make money as they do nothing, similar to people at the FTC and FCC that don't protect us at all, and allow them to continue to have power over us by playing us for fools. Forced arbitration exists because our legislators suck. And in the immortal words of George Carlin, we vote for them. So what the fuck does that say for us? Moving onward. Forced arbitration is best described in this comment that I received that is the best comment I've ever received on my YouTube channel in almost 13 years. If buying isn't owning, piracy isn't stealing. I sent an email to Adobe customer service support letting them know that I'm changing the terms of the sale and allowing myself to own all of their software at no cost. By accepting my email, they've agreed to the new terms of the sale, and in order to file a dispute, they need to send a certified letter weighing exactly 1.337 ounces and sealed with wax the exact color of my asshole. Failure to do so constitutes acceptance of my new terms of the sale. Today's story is about a doctor that died after eating at a restaurant that was at Disney World. So this is a restaurant that was advertised and represented as a restaurant that would accommodate people with food allergies. Not only was it advertised that way, but the person also asked the people at the restaurant, are you able to accommodate my food allergy? This woman had a food allergy that would result in her death if she ate this food. And as you could read over here, a medical doctor visiting from New York, she knew she had a severe allergy to dairy and nuts. They decided to eat here because they advertised and represented to the public that food allergies and / or the accommodation of persons with food allergies was a top priority. She believed that they would have safeguards. They specifically questioned the waiter, and very shortly after that, it looks like she suffered in a severe acute allergic reaction and then died. This is a clear-cut case of when you would want to take somebody to court. If somebody has killed your wife went here, she said, if I have this, this will kill me. It looks like you advertised that you will accommodate me by not serving me this. Sure, we won't serve you that. They serve you that and you die. I can't think of a better case to take to court than something like this. Maybe you disagree. Maybe you think that restaurants should not be held liable for this. Me personally, if I was running a restaurant, I've made careless mistakes before. If somebody said, listen, if I have this in my food, I will die. This is a recipe where I usually make that with that ingredient. I'll be honest, I don't want to be mean. I'd probably tell them, listen, I'm not the restaurant for you. I am genuinely sorry because I don't want to make that risk that if somebody that's working in my kitchen makes a mistake because they work 10 hours a day and they're tired, that you die. Regardless of your opinions on any of this, this is a clear-cut case where somebody should be allowed to have their day in court and hold a company accountable and responsible for killing their wife. Even if you think that they didn't do it, let the judge and the jury decide that, not an executive at Disney. Moving onwards, they are claiming that because he signed up for a trial of Disney Plus, that there's a forced arbitration agreement in there that means that he is no longer allowed to have his day in court with the restaurant. Mr. Piccolo allegedly signed up for a free trial of Disney Plus via the PlayStation game console. Disney Plus is a subscription-based streaming entertainment service offering movies, television shows, and concerts. Mr. Piccolo believes that he canceled the subscription prior to the expiration of the free trial because he has been unable to locate any charges. So, let's say there was a forced arbitration agreement here. There's a number of reasons that this is ridiculous. Reason number one, the obvious one, is that these are fundamentally different services at the company. Let's say that you go to Rossman Repair Group's web forum, and I had a forced arbitration agreement there. I don't, but just for the sake of the example. Let's say I had a forced arbitration agreement there, and that forced arbitration agreement says if I've given you board advice that results in your board going on fire, you can't sue me over that. You have to go through arbitration. If I ran Rossman Restaurant Group, and you go to Rossman Restaurant Group, I advertise us as not having dairy. You say, are you sure this doesn't have dairy? Because if I eat dairy, I'll die. I say, no dairy, I give you dairy, you die. I'm not allowed to say, well, you signed the forced arbitration agreement from my forum that you had a free trial of 4 years ago and never paid for, so that means that there's a legally binding contract with my restaurant. These are obviously fundamentally separate industries that should have absolutely no say. Aside from the fact that I think forced arbitration at its core should be illegal, even if you have forced arbitration, different services altogether. And as it says over here, he never even paid for the service. Now, Disney is saying that by clicking agree and continue that you've agreed to our subscriber agreement and you acknowledge that you have read our privacy policy. Both the terms subscriber agreement and privacy policy were underlined in blue font to indicate that they're clickable hyperlinks. That was Disney's argument. Now, the plaintiff's argument is one that, in my opinion, in this particular section is not made in good faith, and completely wrong. To be clear, I think that Disney should get fucked. I have thought that Disney should get fucked long before this happened. I will think that Disney should get fucked long into the future, and I think that they should get fucked on this case. I just want to make that clear before I point out why, if you actually read this 100-plus page document, you would realize that this is a horrible argument. Importantly, by Walt Disney's own admission through the Morgan Declaration, the acknowledgement Mr. Piccolo allegedly agreed by clicking agree and continue made absolutely no mention of the Disney terms of use and provided no hyperlink to the Disney terms of use. See Exhibit C. Exhibit C is the Morgan Declaration. The Morgan Declaration, for anybody who's curious about that, is a declaration by Sammy Morgan. Sammy Morgan works at Disney and was defending Disney on page 54 of the document. She is a manager of product management, and she is explaining why it is that Jeffrey Piccolo agreed to the particular terms of this agreement, and she is explaining how everything goes. Now, the lawyer for the plaintiff is trying to catch that person in a gotcha, and as much as I hate Disney, I think that this is done in a very dishonest and kind of scummy way. So let's go over it. Made absolutely no mention of Disney terms of use and provided no hyperlink to the Disney terms of use. It only mentioned and provided links to the subscriber agreement and privacy policy, not to the Disney terms of use. Thus, Jeffrey Piccolo would have had no notice, actual or otherwise, of the Disney terms of use. The hyperlink to the Disney terms of use was buried within the middle paragraph halfway down from the first page of Disney Plus subscriber agreement, which itself was a hyperlink on the Disney Plus registration page. See Exhibit C. An unreferenced hyperlink buried within another hyperlink document does not constitute notice. Now, I agree with this. I agree with the idea that if you have a terms of service, having a hyperlink that is hidden many paragraphs down with additional terms of service is sneaky, underhanded, and shitty. And that should not be counted as part of that original terms of service that you signed. The next part of this, in my opinion, is highly disingenuous. It's not just wrong, but it is disingenuous. And I'm going to explain why it's those two things. Simply because I dislike Disney. Same thing with Apple. Just because I dislike them and I have a bias against them does not mean that I'm going to ignore the truth. If I do that, you're never going to trust me again. I do not simply want to ride the wave of people being aggravated and outraged at this while ignoring the facts. I think it's important that we read through the entirety of this 100-plus pages. This is why I believe that this is very kind of underhanded, and just stick with me here because this is going to take a while. It says over here, the plaintiff saying, the Disney registration acknowledgement stated that by clicking agree and continue, you agree to our subscriber agreement and acknowledge that you've read our privacy policy. Both the subscriber agreement and privacy policy were underlined and were in blue font to indicate that they're clickable hyperlinks. Importantly, by Walt Disney's own admission through the Morgan Declaration, the acknowledgement Mr. Piccolo allegedly agreed to by clicking agree and continue made no mention of the Disney terms of use and provided no hyperlink to the Disney terms of use. For anybody who's wondering what the Morgan Declaration is, the Morgan Declaration was a declaration made by an employee of Disney whose job it appears to be to defend Disney. So this person wrote all of this over here, explaining how the website works, and he is simply recounting what she has said. She is the manager of product management. She works at Disney. Her job is to defend Disney. Please keep that in mind. The plaintiff's attorney says that it linked to everything besides the Disney terms of use. Thus, Jeffrey Piccolo would have had no notice, actual or otherwise, of the Disney terms of use. The hyperlink to the Disney terms of use was buried within the middle paragraph halfway down the first page of the Disney Plus subscriber agreement, which itself was a hyperlink on the Disney Plus registration page. See Exhibit C. An unreferenced hyperlink buried within another hyperlink document does not constitute notice. Now, I agree with the concept there that having a hyperlink buried within another hyperlink is not notice. And when you take a look at the subscriber agreement that he is referring to, when you look at the subscriber agreement, A, it's ridiculously long, but more importantly, when we look at Disney terms of use, the Disney terms of use is mentioned several pages down, and it is not clickable. They also have which can be found at disneytermsofuse.com, and one thing you'll notice here is that this is also not clickable. And this is also one of those bullshit websites where they go out of their way to disable my ability to select parts of the page, which is kind of scummy, kind of shitty shit to do. I literally cannot select anything here. You know why you're making Disney terms of use not clickable over here. The way that I can find it if I want to click it is literally go into the bottom over here and go into Disney terms of use. So in defense of the plaintiff, I agree with him in spirit. You cannot have a terms of service that then links to another terms of service with a link that is not even clickable halfway down this fucking 13 page, whatever the hell document. That's bullshit. That's underhanded and that's scummy. However, Is that what actually happens here? And further, let's just look into what this person at Disney said. He is claiming the Walt Disney representative, by their own admission, is saying that they never linked to the Disney terms of use. Let's say that this was not there. I'm just going to assume the worst of Disney here. I'm going to assume that if I looked at archive.org, similar to DCS and Stefan with the battery situation, let's say that they only added this there a day after this woman died. Hypothetically, let's say if that's true, right? By WDPR's admission, he is acknowledging that the subscriber agreement and the privacy policy were there, right? They're acknowledging that he agreed to the subscriber agreement. So let's take a look at the subscriber agreement. When you look at the subscriber agreement, this was updated after she died, but it does very clearly mention that you are subject to arbitration. This must be resolved by individual binding arbitration. So fuck the Disney terms of use for a moment. Let's just forget about the Disney terms of use. The subscriber agreement, which the plaintiff's attorney is admitting and acknowledging this person signed, does mention forced arbitration. Now, at this point, you may think, well, Lewis, what if they did what DCS did with the batteries and they changed it, right? What if they change it? You're not thinking of that. This archive is from September 27th, 2023, which is 1 or 2 weeks before this incident occurred where the woman died. If you take a look through this, you'll notice that even 2 years ago, before she died, there was a section here for binding arbitration. I find this argument to be made in bad faith using logical fallacies, and I also find this argument to be wrong on its face, even if there were no logical fallacies. I want to see if you can figure out what's wrong with that before I point it out. I'll give you some time. I'll wait. All right. I'm going to make 2 statements. Tell me if you could tell the difference in these statements. There is a monitor, a camera, and a light in my room. There is a monitor, a camera, a light, and no water bottle in my room. One of those statements leaves open the possibility that a water bottle is in my room. Simply by telling you what is in the room, I'm not telling you that this is not in the room. That's not the way this works. In the second statement, I am explicitly telling you there is no water bottle in this room. And this lawyer is pretending that because the Disney employee did not mention that there was a Disney terms of use linked on that page, that she was explicitly stating that it wasn't there. That is a logical fallacy. That is underhanded, sneaky shit and misinterpreting what she said. Simply because she didn't have her morning coffee and didn't put it there does not mean that the difference between an explicit statement and it simply not being included there is not a difference that is important. Secondly, even if I give the attorney the fact that that wasn't there, it doesn't matter because his attorney is accepting that the subscriber agreement is what he agreed to. He's accepting that premise from the Disney employee. And if he had taken 5 seconds to look at the subscription agreement, he would have seen that there's a forced arbitration clause right there. And you could even see it in archive.is. What this means is that a random fuckface on YouTube that didn't even shave today, that's having a horrible day, did more research than this attorney. I went to a really interesting talk yesterday at Capital Factory where it was given by Mr. Drew Harris. He's a civil rights lawyer. Shout out to him. And also shout out to Kevin W. at EFF for arranging all of this. It was about generative AI and it was about lawyers using generative AI. It was about the penalties that they face and also the ethics of using stuff like ChatGPT to write this. I think just because this brief is 120 pages doesn't mean it wasn't written by ChatGPT. If a dude on YouTube who's unshaven, who's had a shitty day, who has no legal experience, is doing this research, like, why can't you when you're getting 400 or 800 or 1200 an hour? It's not just the fact that it's kind of an underhanded and shitty argument with logical fallacies. It's also the fact that it's functionally wrong, and it should be very, very easy to pin Disney based on fact without having to make things up. This is all a giant red herring, because at the end of the day, none of this shit is going to matter. If you take a look at this over here, even if Mr. Piccolo had consented to the Disney terms of use, which he did not, yes, he did. Most likely, yes, he did. Which he did not, and his consent was binding on his wife's estate, which it is not. The discrepancies between the Disney terms of use and the My Disney Experience terms and conditions create a glaring ambiguity. What is the Disney My Disney Experience? My Disney Experience is the application that he used to purchase his ticket to Epcot. So this is a separate application altogether. The My Disney Experience terms and conditions create a glaring ambiguity, rendering the arbitration provision in the Disney terms of use unenforceable. More importantly, the My Disney Experience terms and conditions expressly provide that they will apply in the event that they directly conflict with the terms of use. If you do not agree to these terms, you may not use the site or app, blah, blah, blah. These terms apply in addition to and not in lieu of the Disney terms of use found here. In the event that these terms directly conflict with the applicable foregoing Disney terms of use, these terms will prevail. In layman's terms, if what we said over here conflicts with the agreement that you signed 4 years ago, fuck the agreement you signed 4 years ago. What we're saying over here is what matters. When you take a look at that agreement, you'll see that there is no binding arbitration in here. It actually says that you have the ability to take them to court in Orange County, Florida, which they did. Now, this just creates a very funny legal conundrum over here, which is the whole question of this says that this document, which does not have binding arbitration and allows you to take them to court, supersedes the Disney terms of use. But does that supersede the Disney subscriber agreement? I'm just going to assume that it does. I'm not a fucking lawyer. Go to Uncivil Law or Legal Eagle for that shit. It's very clear that Disney is saying if these agreements are in conflict with each other, the agreement that has nothing about forced arbitration that allows you to go to court is the one that wins. And fuck all of these for one individual moment. The estate of this particular woman who died is separate from Jeffrey Piccolo. Jeffrey Piccolo bought her a ticket, but that doesn't mean that their estate can't sue. Hypothetically speaking, let's say that I purchase my girlfriend a ticket to go to Epcot. I break up with my girlfriend. She goes to Epcot. She dies. Her family decides to sue Epcot. How the fuck is it that the family's estate cannot sue Epcot for their daughter's wrongful death because her ex-boyfriend bought her an Epcot ticket and agreed to something? So on multiple levels, you see how this makes no sense. Disney does not have a leg to stand on. Disney is trying to do everything in their power to get around taking accountability and responsibility for what they've done wrong. In conclusion, even if we go through all this stuff, Jeffrey Piccolo has Disney absolutely dead to rights on all this. I did actually read through the 100 plus pages of this, even though I'm having a genuinely shit day, because it's important to go through the primary source documents. It's important to give the devil its due. The reason that I went through all of this is to demonstrate, even if I were to steel man every single one of Disney's arguments, they still deserve and should get fucked legally. Jeffrey Piccolo signed up for Disney Plus. Even if there was some sort of terms that he agreed to, doesn't matter because he canceled his account prior to even getting billed for it. Even if his lawyer is wrong, and his lawyer was wrong about the subscriber agreement and the whole Disney terms of use shit, it doesn't matter because Disney's agreement for the application where you purchase your ticket says that if they conflict with the terms from Disney Plus, that the terms from the ticket purchasing application for the restaurant is the one that takes precedent. And in that application, that terms of use says that you're allowed to take them to court in Orange County, Florida, which is what he is doing. If you were to ignore all of this, let's just say that in every single terms of use, it said forced arbitration every step of the way. Even if that was true, even if that was true in the ticket application, it doesn't matter because her estate is separate from him. Let's say that I agreed to this forced arbitration crap. I purchased my girlfriend tickets to Epcot for 3 months from now. She goes to Epcot 3 months from now. She goes to Epcot, has a great time until the waiter kills her. Her mother decides to sue Epcot because of her daughter's wrongful death. Her mother did not sign a forced arbitration agreement. I did. The same way that this person who got sucked into forced arbitration on socks was opted in without actually signing anything, the mother of the person who was killed wrongfully did not opt into any of this. He is the head of her estate, but he is representing the estate. The estate did not sign any forced arbitration agreement. No matter how you look at this, Disney deserves to get fucked. They earned getting fucked, and they are legally in the wrong. In my opinion, forced arbitration in its entirety, across all fields, whether we're talking about refrigerators, socks, televisions, video games, restaurants, all of it should be illegal. I should have the ability to take you to court if you have fucked me. If you are a large company and I can prove with objective facts and evidence that you have broken the law, I should have the ability to bring that before a judge and a jury. At the very least, if you're going to take that away from me, at the very least, can you give us some real consumer protection in America? Because this kind of reminds me of the abolish the police shit that was happening 4 years ago in New York. To be clear, I like the Second Amendment and I would like to have a functioning police and a sheriff. But if you had to eliminate this, you only get to eliminate one. You cannot say that there's no Second Amendment and abolish the police. No, pick one. Ideally, there would be neither of those that get picked. But if you're going to advocate for this, pick one. I either get to have a gun or there's police. There cannot not be police and no guns. No, we're not doing that. Give me consumer protection or allow me to take companies to court when they have fucked me over. It's one or the other. And the fact that there is no legislation that has been pushed through successfully against forced arbitration demonstrates that our politicians don't care about us, and they never have. They care about pursuing power, they care about pursuing getting paid to do nothing, and they don't care about the American people. They separate us via culture war bullshit that will rile us up so that we'll vote for them and get excited to vote for them, like we're watching wrestling after Kurt Angle smacked Stephanie McMahon while Triple H was watching on camera so that we all got riled up. I want to say Triple H. That's the way politics works nowadays. We get all riled up about these particular issues so that we get excited, so that we're mad, so that we go to vote, and then we vote people in that do not give two shits of a fuck about us in every single way. And it's on us. Because as George Carlin has famously said, if our politicians suck and we complain about them, and we vote them in, and they're from our society, what the fuck does that say about us? That's it for today, and as always, I hope you learned something. Let me know what you think in the comments down below. I'm going to go find something to do so that I can distract myself from life in general at the moment, and I'll see you in the next one. Bye now.
You see him? That's my baby fishy. Look at him. Look at him, he's sleeping inside the plant. See, the idea is I got enough plants here. These are pieces of shit, by the way. Never get these to put in the pond. So the thing is, the pot is not really heavy enough, nor is the dirt in there heavy enough. On that side, what I actually did is I managed to be I was crazy in that I actually put another pot in there. So I put another pot, I filled it with rocks, I drilled holes in the side of both pots, and I tied it with headphone wire. It still manages to find a way to tip over. I hate that plant, like with a passion. Like, yeah, the seed over there, it's just, I'm never going to get that thing to stay straight. It drives me insane. I hate that plant so much. I swear, that plant is as defective as a 14th generation Intel processor. Come on. I'm going to figure out the plant shit at some point, but that's not the point of today's video. Look at the baby fishy. He's got so many places to hide from the big fish that want to eat him. Because nobody's going to fit in. Like, a big fish is not going to be able to get around all this. So I kind of wanted to put all this stuff here so that the baby fishies have places to hide. And they have all these little places to hide in here from the big fishies that may want to eat them. And the best part is, because there's all these plants, they have places that are filled with oxygen to hide. So, hopefully happy fishy. Over there you got the asshole fishies that are trying to eat my big fishy and my little fishy. See, they're swarming like the piranhas that they are, but they can't find them. Anyway, I'll see you later.